Defendant Ryan Routh motion to recuse the Honorable Judge Aileen M. Cannon. If you aren't familiar with these two, the Ryan Routh in this case is the man who was accused of attempting to assassinate Donald Trump in Florida. Judge Aileen Cannon is a Trump-appointed judge appointed at the end of 2020 who was the one overseeing the classified documents case in Florida. There was a lot of people saying she was biased during that case, and eventually it got dismissed. That led to people calling for her to be impeached, and Donald Trump has continuously praised her. All of that is very important for this motion. The defendant in this case, Ryan Wesley Routh, respectfully moves Your Honor to recuse herself from this case pursuant to the Due Process Clause and the federal recusal statute. This motion is warranted due to the unique facts and circumstances of this case and this court's relationship to the alleged victim. Recusal by Your Honor is essential to preserve the appearance of impartiality. Mr. Routh stands accused of attempting to assassinate Donald J. Trump. He faces up to life in prison. This case has already attracted significant media attention. It will continue to do so, and the court's rulings are likely to face intense public scrutiny. This motion presumes that this case would preside over this case in this court. This motion presumes that this court would preside over this case impartially. Sorry about that. Hopefully, given the heightened stakes and the public scrutiny, there should not be any doubts about even an appearance of impartiality of the presiding judge. I think this is fair, right? If you are someone where the victim is going on stages and going to interviews and making posts on social media about how great you are and you did so good by them, and they also, are the ones that appointed you, and they're the victim in the case, the recusal there's a lot there. Although Mr. Trump is the alleged victim here, he previously served as President of the United States. When in office, he nominated Your Honor to her current position as a U.S. District Judge on the Southern District of Florida. Your Honor thus owes her lifetime appointment to the alleged victim in this criminal case. This is a reason people believe she should have recused herself in the documents case as well. Of course, that didn't happen. After Mr. Trump left office, he was charged in this district with 40 felony counts relating to his retention of classified documents. Your Honor recently presided over that criminal matter, ultimately dismissed the case against Mr. Trump. Mr. Trump is the current Republican candidate for president in next month's election. On the campaign trail, he has repeatedly praised Your Honor for her rulings in this case. As the alleged victim here, he has a significant stake in the outcome of this case too. Were he to become president in the future, he would have the authority to nominate Your Honor to a federal judgeship on a higher court were a vacancy to arise. Taken together, these unprecedented facts and circumstances might create an appearance of impartiality in the mind of the public. Accordingly, the Constitution and the federal recusal statute require Your Honor to recuse herself in this case. It is axiomatic that a fair trial and a fair tribunal is basic requirement for due process. The Due Process Clause may sometimes bar trial by judges who have no actual basis, who would do their very best to weigh scales of justice equally between contending parties, but to perform its high function in the best way, justice must satisfy the appearance of justice. So basically what they're saying is they're not accusing her of being impartial, right? They're not preemptively accusing her, but they are saying that the public is probably going to assume that. Therefore, it's best if she's not partial to it. Get a different judge, right? Just get a different judge, solves it. This foundational principle is also codified in the federal recusal statute as relevant here. Any judge in the United States shall disqualify herself in any proceedings in which her impartiality might reasonably be questioned. A judge is under an affirmative, self-enforcing obligation to recuse herself whenever the proper grounds exist, and stating that a district judge has the initial responsibility to recuse herself from a case. However, where the judge does not recuse sua sponte, a party may move for the recusal of a judge under 28 U.S.C. 455. So honestly, she should have recused, I think, as soon as this landed on her desk. There's just too much, right, in my opinion. The court has examined that the very purpose of 455A is to promote confidence in the judiciary by avoiding even the appearance of impropriety whenever possible. As the federal judiciary's catch-all recusal provision, What matters for purposes of 455A is not the reality of basis or prejudice, but its appearance. Quite simply and quite universally, recusal is required whenever impartiality might be reasonably questioned. I think it's fair. I think it's fair to make that question because the decision in the previous Trump case and this one could literally change her career. More so than maybe other judges because she's already being praised by Trump. She was appointed by Trump. This overriding concern with appearances as opposed to the existence of, in fact, of any bias or prejudice stems from the recognized need for an unimpeachable judicial system in which the public has unwavered confidence. In accordance with 455A's text, mandate recusal whenever a judge's impartiality might be reasonably questioned. Recusal is evaluated on an objective basis. In other words, 455A deals with an objective appearance of impartiality, rendering the judge's subjective bias or knowledge irrelevant. Specifically, 455A requires recusal where an objective, disinterested lay observer, fully informed of the facts, may underlying the ground in which recusal is sought would entertain a sufficient doubt about the judge's impartiality. And again, I think that's fair. I think this is a fair argument. I think she's going to do it. I really think she's going to do it. If she's not going to do it, to me, that makes more grounds that she probably should have recused, if that makes sense, right? To me, not recusing it's a red flag. Importantly, the 11th Circuit has repeatedly stressed that any doubts must be resolved in favor of recusal. This too follows from the text of the recusal statute. In addition, the use of the word shall make recusal mandatory. The use of might reasonably be questioned clearly mandates it would be preferable for a judge to err on the side of caution and disqualify herself in a questionable case. Indeed, the language of 455A was specifically designed to eliminate the so-called duty to sit that had governed the previous recusal statute. 455 does away with the old duty to sit doctrine and requires judges to resolve any doubts that may have in favor of disqualification. The reason for this change, adopted back in 1974, was as follows. The disqualification of a judge in any given case does not cause a delay or inconvenience which resulted in prior times. The growing number of federal judges and the availability of rapid transportation to move those judges from place to place when necessary make the decision to disqualify much less burdensome on the judicial system than in past times. Any inconvenience which does arise is more than outweighed by the need to protect the dignity and integrity of the judicial process. The pragmatic rationale applies to this particular course here, where recusal is sought at the outset of the case before the judge has expended any resources, or when the case is brought in a district with numerous other capable judges who are available to preside over the case without any possible appearance of partiality. Rule necessarily, a judge is not disqualified due to a personal interest if there is no other judge available to hear her case. The rule is generally invoked in cases in which no judge in the country is capable of hearing the case. Emphasis added. Then there's grounds for disqualification. We have recusal decisions under 455 are extremely fact-driven and must be judged on their unique facts and circumstances more than by comparison to situations considered in prior jurisprudence. If any case illustrates the wisdom of that proposition, it's this one. The facts and circumstances of this case are sui generis. The specific grounds for recusal are set out below. The simple act of reassigning the case to another judge would vacate all of them. Again, if I mispronounce anything, I am sorry. It's been a long day. The alleged victim appointed Your Honor to the bench. As an initial matter, it is a historical fact that while serving as the 45th President of the United States, Mr. Trump nominated Your Honor to be current judgeship in May 2020 by itself. She took the bench in November, I believe. I think I said she was nominated in November. If I said that earlier, it's wrong. She took it. I'm pretty sure she appeared first in November. I literally just looked it up beforehand. Maybe I'm wrong, but let's continue. Maybe they'll mention it. By itself, this fact is by no means disqualifying. After all, federal judges and justices routinely preside over cases involving the president that nominated them. Indeed, the oath they take requires them to set aside any personal loyalty that they might feel towards the president who appointed him. At the same time, this dynamic must still factor into the recusal analysis. The reason is that people who have not served on the bench are often all too willing to indulge suspicions and doubts concerning the integrity of judges. Unlike judges and members of the legal profession, the public may not grasp that a judge is obligated to set aside any feelings of personal loyalty or gratitude. Indeed, members of the public may question whether doing so is even possible. So when a judge is presiding over a case involving the very president who appointed her, members of the public may suspect the judge will wish to return the favor. This was a suspicion that is also verified as a suspicion people had. As I said previously, people believed this. And that was a reason people said she should have recused, because the public were questioning it, especially in something as high profile as a criminal case. But let's continue. In this case, that concern is particularly salient. Normally, a federal judge may be required to resolve a dispute involving an official policy, regulation, or program developed by the current president's administration. This case, however, involves no official policy, regulation, or program at all. Rather, a former president involved in this case in a purely personal capacity as the alleged victim of a crime and an assassination attempt, no less. In the mind of the public, this visceral context may make it even more difficult for a judge to set aside personal feelings of loyalty or gratitude for the president that bestowed on her a lifetime appointment to the bench. Finally, the unprecedented nature of this scenario militates in the favor of recusal. Indeed, it is unclear whether the scenario, a federal judge presiding over a criminal case for the very president who appointed her as the alleged victim of a violent crime, has ever occurred in the history of this country. At the very least, that the alleged victim in this criminal case appointed Your Honor to her current position is a factor that can and should be considered alongside other factors discussed below. Of course, there's more. Mr. Trump has publicly praised this court for its ruling. While Mr. Trump is the alleged victim in this criminal case, the court has previously presided over cases in which he is a civil plaintiff and a criminal defendant. During those cases, this court issued some rulings that were favorable to Mr. Trump. One of the rulings was stayed and the other then vacated on appeal. Other rulings were characterized by some in the media as unorthodox. In July, this court dismissed the criminal case against Mr. Trump in its entirety. That ruling is now the subject of an appeal in the 11th Circuit Court, compounding the potential appearance of impartiality. Mr. Trump himself has positively invoked and repeatedly praised this court in public for his rulings in his case. And he's doing this, of course, while he's not president right now. So as a individual citizen, and recently he's doing this praise. While this court had little control over how Mr. Trump responded to his rulings, Mr. Trump's social media page immediately invoked this court's dismissal, ruling in support for dismissing several other legal proceedings against him, including the federal case brought by the special counsel in the District of Columbia, which I'm going to mention now. There's going to be a big, massive evidence dump tomorrow, from my understanding. Trump team tried to delay this. I don't know if I'm going to cover it or how I will. It's probably going to be heavily redacted, and the best way is going to be after people go through and fill in the blanks for what we know. And the dismissal said, this dismissal of the lawless indictment in Florida should be just the first step, followed quickly by dismissal of all the witch hunts, the January 6th hoax in Washington, D.C. Trump's immediate invocation of the court's dismissal ruling may have made it difficult for the public to disentangle this court's ruling from Mr. Trump's political campaign. They're putting on a good argument. Like, going in, surface level, I thought this was obviously going to be argued. They are making a very solid point. This court is now part of his political campaign. It is. Trump's made it that. A few days later, Mr. Trump praised this court's ruling in your honor by name during his acceptance speech at the Republican National Convention, viewed by over 25 million people. He stated on Monday a major ruling was handed down from a highly respected federal judge in Florida, Aileen Cannon, finding that the prosecutor and the fake documents case against him were totally unconstitutional, and the entire case was thrown out of the court. The audience applauded after that line. The media also reported this aspect of the speech, further amplifying its praise of this court and ruling. So they're saying 25 million people watched it, then the media and social media, they're going to spread it. Trump has otherwise praised this court, both before and after the dismissal. For example, commenting on a pending motion to continue the criminal trial early in this case, Trump went on live TV and praised your honor. I know it's a very highly respected judge, a very smart judge, a very strong judge. When the host observed that Mr. Trump appointed your honor to the court, he responded, I did. I'm very proud to have appointed her, but she's very smart, very strong, and loves our country. We need judges that love our country, so they do the right thing. Just last month, Mr. Trump gave a press conference where he praised your honor by name, again stating, I wasn't surprised because I don't get friendly panels. But where I've had fair judges, where we've had brilliant judges, frankly, I don't know the judge in Florida, Judge Cannon, don't know her at all, but I think she's a brilliant woman. I think she handled a scam. It's a scam case. That's the documents case. And of course, he knows her. He appointed her, right? That's so weird. He says, I don't know her. By repeatedly and publicly praising this court by name, Trump could have forgotten. That's fair. He is old. By repeatedly and publicly praising this court by name for its rulings in this case, Mr. Trump has arguably bolstered the perception that the court is partial in his favor. Moreover, were Mr. Trump to become president again in the future, he would be in a position to nominate your honor to a vacancy on a higher appellate court, including the U.S. Supreme Court. I was going to say that earlier. I was like, they're lowballing it. This is a Supreme Court thing, right? Like, she saved Trump. She's going to end up on the Supreme Court. There's an opening in my mind. And in the mind of the public, this prospect of a judicial promotion could arguably affect this court's ability to be impartial in this case, where Mr. Trump is the alleged victim and has an interest in the outcome. Recusal would remove any public perception that Mr. Trump's case have assigned to this court in a non-random manner. Finally, the media previously reported that the odds of this court receiving either the civil lawsuit by Trump or the criminal case against Trump were low, prompting questions about the randomness of the case assignments. I remember that. This is the now third case involving Mr. Trump that has been assigned to this court, which has already been described as a remarkable coincidence. Given these low odds, the public may suspect that Mr. Trump's cases have somehow been deliberately steered to this court. That perception would irreparably damage the integrity of this court as an institution, not to mention the judicial process. To be clear, there is no evidence that this case or any other was assigned in a non-random manner, but conspiracy theories have based on less. Recusal would thus have added benefit of preventing the public from harboring such dangerous perception. People talk about like 2 times coincidence, 3rd time's a pattern. That's not to say that that's what's happened. It probably hasn't. It probably is pure coincidence. But people, what's the public going to think, right? Are you going to have it in the back of your head? This motion assumes that this court has no actual basis, would do its very best to weigh the scales of justice equally between contending parties, but to perform its high function the best way. Justice must satisfy the appearance of justice. The unprecedented facts and circumstances of this case, at the very least, create significant doubts about whether this court would preside consistent with the requisite appearance of impartiality, and any doubts must be resolved in favor of recusal. Accordingly, Mr. Routh respectfully requests this court grant this motion and recuse from this case. Pursuant to Local Rule 88.9 on October 2nd, 2024, the counsel for Mr. Routh conferred with the government by phone to advise that the defense would be drafting a recusal motion. On October 16th, counsel for Mr. Routh spoke with the government by phone and later emailed a draft of the motion to the government. On October 17th, the government replied that taking this motion under advisement. I don't see the government saying no. The only one that can say no is Judge Aileen Cannon. And I don't see a reason for her to not recuse. Except, this is what I was saying earlier, where I was like, if it made sense. The only reason I could see in this situation, when she has to have the burden of the appearance of impartiality, this is the 3rd case, Trump's praising her recently, is if she thinks she needs to do this case to get more praise from Trump to then get a higher position, which is the exact type of insinuation that they're not making, but they have to assume the public might make, and the public might making that assumption is going to be a reason for her to recuse. Basically, I mean, I don't know how she doesn't. I don't know how she doesn't recuse. This is not a good look, right? And the appearance of it, the look of it, is what matters here. This doesn't mean he's going to get off or anything like that, right? But if she doesn't recuse, you know this is going to go, that her possibly being impartial, her not being impartial, her being biased, is going to lead to appeals. We know that, right? I think everyone knows that. Democrat, Republican, left, right, not from America, knows that. I think she's going to recuse. I can't imagine she doesn't. I can't.